Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're asking the question, what is a normal processing time for a K-1, CR-1, K-3, or IR-1 visa petition? What are we talking about here specifically? We're talking about petition processing at Department of Homeland Security, specifically the United States Citizenship and Immigration Service. So for those who are unaware, for all of the aforementioned visa categories, and that's primarily what we handle here in this office, a lot of family-based immigration for fiancés and spouses or children and stepchildren of United States citizens. We handle a lot of that here, and we process a great number of those cases through the U.S. Embassy here in Bangkok as well. The question posed, though, is what is a sort of a normal processing time parameter associated with these petitions? You know, it's been a source of great consternation in my practice with regard to immigration that USCIS even puts out these sort of processing time estimates and things, because all it really does, it creates, in my opinion, it creates a lot of false sense of there being a set timeline, and it also creates in many ways a false sense of what ought to be, what is the correct processing time. At the end of the day, I got to be honest with you, especially now where I think our immigration system is largely broken and it's in desperate need of reform and overhaul, setting that aside, there doesn't seem to be a lot of rhyme or reason with regard to how some of these cases process. Every once in a while, I get a wild card that will throw in the hopper and then boom, it just comes right back. That's not very common, I will admit. COVID, my gosh, we just saw a total freeze of the overall process, and quite honestly, it's been thawing, but you know, I don't think it's safe to argue that we're back to status quo ante in terms of processing times prior to COVID. But a lot of people ask me about this, and you know, look, I'm not going to give anybody a hard and fast rule. There's certain parameters depending on the underlying petition you're processing. Again, you're dealing with an I-130 in the case of the CR-1 and the IR-1 visa, I-129F in terms of the K-1 or the K-3 supplemental. Those are different lines, if you will, for visa adjudication or petition adjudication. So again, they're going to differ just internally from the fact that they're not processing through the same pipeline, if you will. Meanwhile, again, one case will seem to come out very quickly, another case will take forever. There doesn't seem to be a lot of rhyme or reason. There does come a certain point, though, where after a certain period of time, you have to start asking yourself, well, do we need to go ahead and perhaps look at doing something like a writ of mandamus? I made another video contemporaneously with this one where I discuss writs of mandamus and sort of what I think of them. I'm looking at that from sort of an outsider's perspective because it's not something I deal with on a regular basis, because quite honestly, I'm in a unique position being abroad and dealing primarily with consular processing. But leaving that aside, the answer to the question is, rather than looking at it as like a set period of time, which is normal, I kind of look at it as like a banded thing. You know, if it comes out before X date, wow, that came out really fast. And if it comes out after a certain period of time, it's like, wow, that one went slow. There is a sweet spot in there, and that said, a good immigration attorney, in my opinion, will have kind of a feel for, hey, at a certain point, the clients are saying, you know, it's been X amount of time, I've been waiting around here forever, what do you think? And oftentimes it will get to a point where it becomes just, in my opinion, completely unreasonable, where it's like, hey, we might need to look at taking some different steps to handle this. That said, again, it's going to be driven by the underlying facts in a given case as well as the circumstances in a particular case. So not to sound like a broken record, but the facts are going to drive the analysis as to whether or not a petition is taking too long to process.